Happy Friday. We have made it and it is the beginning of the weekend. Thank you for joining me. This is Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. And if you enjoy those type of content, please go ahead and share, like, and don't forget to comment below. And you might find those information are very useful. If not useful to you, please share along because it might apply to somebody that you might know. Okay, let's get right into it. Today's video, I'm just going to go ahead and give you a couple tips on different type of topics. We'll talk about asylum, we'll talk about adjustment of status and the admissibility issue, and we'll talk about waivers and secret to winning waivers. Okay, let's start with asylum. What is it that people are missing with asylum? Asylum is a relief, okay, that can be given to you if you have a story of persecution. We already know that asylum is based on fear of persecution, whether it is past persecution or persecution in the future or present persecution. But anyway, it is based on well-founded fear of persecution. The type of fear that you have that if you go back to your country, then the government that is in your country are not going to protect you because they do not have control over those type of activities that are going on. Basically, that is the foundation of asylum. But where it gets messy is when first you miss the deadline. Asylum must be filed within 1 year of you being physically present in the US. Okay, you might miss the deadline because you have exceptions. And what are those type of exceptions that you might have? Exceptions can be based on your current situation. Maybe you came here with a student visa and things happen drastically that change your circumstances, and that's why you couldn't apply earlier and you're applying now. And let's say you have a child that is sick, too sick for you to even sit down to have an application done. That's why circumstances, okay, changed. That's why you're applying late. Let's see, maybe you were in a some type of lawful status, a marriage that didn't work out, not because of your fault, but because it just didn't work out. Not you found yourself out of status and you want to claim asylum, but still you have to have a basis for it. Okay. So, and when you claim your asylum case and you go to the immigration officer, make sure that your story lined up with your evidence. Okay, you cannot have a story telling something else and evidence showing something else. That's where the officer finds inconsistencies, and once they find inconsistencies, they send you to the they will send you to the immigration judge, and that's when you get a notice to appear, for you to appear before the immigration judge. And once you appear before the immigration judge, my friend, you are already in removal proceeding. Now the question of deportability, or what they say, removability. So you become removable because you are actually in removal proceedings. And if the removal proceedings don't work in your favor, my friend, you become removable. So those are the things that you might avoid earlier on. But let's say you're already there. Okay, what are some other type of reliefs? We talked about cancellation of removal, and we talked about withholding of removal. Remember, the asylum application has two parts to it. Okay, it has application for asylum and withholding of removal. When you apply for asylum, okay, if your asylum get granted at the asylum office, then then it's done. Then you can adjust status, okay? But if your asylum doesn't get granted there, you go into removal proceedings. And sometimes it gets granted there as well. But sometimes it doesn't get granted there. That's when you jump into withholding of removal. So now you don't want them to remove you. And now the standard goes higher. Now you have to show again why you don't want them to remove you, because they've already established that your asylum case cannot be granted. So that's when we come up with those extreme hardship type of argument, okay? But those extreme hardship type of argument in withholding of removal or in cancellation of removal, that's a higher standard to prove. It's not the same as when you're applying for a waiver. The standard goes really high because we have to find unusual circumstances, okay? Those are things you have to keep in mind when you're applying for asylum. My friend, you have to make sure that your story has evidence to back it up, and it has to be consistent, so that when you tell it so straightforward to the point where the officer will have no doubt in their mind but to grant you your asylum case. We hope that your case goes smoothly, but if not, we're here to help. You can call my office, 202-751-2180, and please be advised, consultation fees apply. That's it for asylum, okay? At least for today, because there are a lot of things to talk about asylum, but I just wanted to let you know how you can avoid it, really to avoid that your case be referred to an immigration court, because when it gets there, it changes the entire situation, the dynamic, and then you have charges on your notice of appear. And remember, those charges can be also amended. At first you saw discharge, and then when you go to the your first master hearing, calendar hearing, then you see other charges. You just like, okay, where this one is coming from, because they can actually amend those charges. So you don't want your case to get there. So let's get it straight at the asylum office, okay, with the asylum officer. That's what I wanted to say. Then we talk about admissibility. That's when you want to adjust a status. When you want to adjust a status, they have to find you admissible. If you're not admissible, then you cannot adjust the status. Some people make a mistake to actually just file the form I-130, I-485, everything together because they think they are qualified. Of course, you have to know that the form I-130, family petition, and the form I-485 get adjudicated separately because they have different bases of requirements. The form I-130 is just pretty much saying that this person is qualified to petition for you. For example, if you have a parent, okay, or let's say you are a child and you already past 21 and you want to petition for your parent, and you file the form I-130 and combine with I-485 and all those other requirements, okay, you file those forms. But remember that the I-130 will get approved, of course, because once you meet the requirement, you're a U.S. citizen, you pass 21, and then you're working, you have income to show that you have no criminal record, no nothing. So it's going to get approved easily. That's why people get confused. How come I have a I-130 petition approved, but I get a I-485 petition denied? The reason they're denying the I-485, the green card petition, because they have found you inadmissible on certain grounds. So that's what we're going to address today. You can be found inadmissible on multiple grounds, okay? The common one is unlawful presence. If you have been in the US, at the moment you are adjusting the status, you have to find yourself lawfully present. If you're not lawful, chances are that you have accrued a lot of unlawful presence that triggers those 3 years or 10 years bar. of inadmissibility. That's when it gets complicated, and that's when you have to have a waiver filed so that they can waive that unlawful presence in order for you to be able to adjust status. The common one really we see is unlawful presence. Another one could be crimes, okay, felonies, crime of moral turpitude, that those are just moral turpitude are crimes involving immoralities, okay? And then we have other multiple misdemeanors can make you inadmissible as well. And then we have some other people have entry without inspection. Entry without inspection as well can make you inadmissible. So, but they have an exception to it is the grandfather clause. Basically, if you apply before April 30, 2001, I believe, that's when you can pay a penalty, a $1,000 penalty fees, and then they can waive it, and then you can just adjust status. But sometimes you have missed those deadlines as well. Then you have to come to a waiver, okay? So now we go to the subject of waivers. And how the waiver works is that, remember, waiver is discretionary, meaning that you can be qualified but still don't get a waiver granted to you. So the secret to a waiver is storytelling. First, you have to meet of course, you have to meet statutory requirements, meaning that let's say, for example, if you are applying for a waiver of 10 years, like you were barred for 10 years to adjust status. So let's say statutory requirement in that instance will be that the 10 years has already passed, okay? So now you have met your statutory requirement. So now you still need to apply for a waiver. And then now when you're applying for a waiver, because you have met your statutory requirement, you are qualified, and then you have qualifying relatives, meaning you have children. When we talk about children, we're talking about children under the age of 21, and maybe you have a spouse, maybe you have parent. All those people are either lawful permanent resident or you're a citizen, okay? But in certain cases, those are rare cases where they can take somebody who's not a lawful permanent or a U.S. citizen and consider them qualifying relative for the purpose of your waiver, provided that they look at the entire circumstances, okay? They look at the totality of circumstances. But put that one aside. But let's talk about that you have already met the statutory requirements, okay? Now, what can you do for your waiver to be really successful? It's about storytelling. You have to be able to tell a very compelling story to the point of compassion. You know, for example, let's say you have a child that you're claiming a hardship for. Let's say you have a U.S. citizen child, but now you want to adjust status, but you cannot adjust because you were previously found inadmissible. How are you going to use that to at your advantage? You have to really talk about how is it really difficult for a child to live without a parent, a present. So that's if, let's say you were outside of the U.S., you want to actually come here, be admitted, and then adjust your status. Or you're here, you don't want to go back because if you go back, then your child will be left alone. And remember, you go back again, you trigger another bar. So it gets really messy with those 3 years and 10 years bar. One day I'm just going to talk about those alone, like a standalone subject. But today we're just giving general tips. But anyway, back to the subject. So the story has to be compelling, compassionate, and very emotional filled so that they can feel the compassion and they can feel the pain through the writings that we are writing, okay? Sorry about that. But so you have to show how difficult it is to leave your child alone without being raised by both parents. We know, no offense, but we all know statistically that children that are brought in a household without both parents, most of the time they don't turn well. are based on statistics. That's not everybody. Don't come after me. That's not everybody. I'm talking about general statistics, okay? And that's the story that you can actually tell too. And let's say you have somebody who's sick, and let's say you've been here for a long time and you can just go home because you've been so detached with home, and really going home just with nothing too. It's just like, it's stressful, and it's just add a lot of emotional pain to the current situation that you are going through. So that's what I'm trying to say. The waiver has to be really done in a way that is emotional, compelling story, a storytelling to the point where somebody reads it, they feel compelled to help, and they feel compelled to pardon because you have already met your statutory requirements and you have qualifying relatives, and now really what they can only do is pardon you so that you can adjust your status. That's all there is to it. And remember, it's still discretionary. We do our best and hope for the best, okay? So that was it for today. I want to mention something about the bill. Next week, my friend, the Congress will come back because they're in session. I'm telling you, those people are always like on vacation. Sometimes I wonder if they really work. So we have to be able to start holding those people accountable to their actions, because next year we're going to another election. That's when we have to make up our mind and decide for ourselves who are we going to vote for, because it doesn't look like they're working. They're always on vacation. It's always recess. It's always this. It's always this. And now the bill is just sitting there. No movement, none whatsoever. We don't know what's going on. They promised us by the week of April 15, we should know something, which is next week when they come back from recess. Hopefully they're going to talk about it. Now everybody's focusing on the crisis at the border, which we know that crisis has been there for years, okay? It's not a new subject. They just have to deal with it the way they're supposed to deal with it. But in the meantime, they have to do what needs to be done, okay? Please don't forget to comment below, okay? And please don't forget to call my office if you have additional questions. But just remember, consultation fees apply, and you can email me as well. My email is on display. Consultation fee still applies, okay? And that was Bijoux Ngwanda, immigration lawyer in the DC metropolitan area, and this was U.S. Immigration. Until next time, bye-bye.